start. The petitioner has approached this court in the instant writ petition filed under Article 32 of the Constitution of India. Stop. During the pendency of this petition, this court passed an order on 13/2/2019 requesting the MP High Court for reconsideration of the issue of reinstatement of the petitioner in service. Stop. The full court of the MP High Court rejected the said representation in its meeting held on 15th February 2019. Stop. The bench of this court expressed that the said bench should not deal with the matter on merits and directed the matter to be placed before another bench. Stop. It appears that thereafter again suggestions were made by this court to the parties to amicably settle the matter. Stop. It appears that at one point of time this court also suggested that the respondent number 1 should reconsider the issue of petitioner's reinstatement in service and that after reinstatement she could be sent on deputation outside the state or she could be adjusted in some other state. Stop. It is the case of the petitioner that though the said suggestion was acceptable to her, the MP High Court reiterated its stand. Stop. In this background, the matter has come up before us. Stop. At the outset, it is to be noted that counsel for the petitioner clarified that the petitioner is not pressing the present matter on the ground of sexual harassment by Justice A, but is limiting her submissions with regard to the transfer order being illegal and malified and the consequent resignation amounting to constructive dismissal. Stop. We have therefore refrained ourselves from making any reference to the allegations of sexual harassment made in the petition. Stop. We have also refrained ourselves from mentioning the name of Justice A or any of the judges of the MP High Court who, on the administrative side, had some role to play in the matter. So, also the members of the district judiciary who were directly or indirectly involved in the present case. Stop. Shrimati Indira Jaisingh, learned senior advocate, submitted that the MP High Court was bound by the transfer guidelines oblique policy of the High Court of Madhya Pradesh. Stop. She submitted that as per the transfer policy, the annual transfers normally take place by 15th of March every year and the judicial officers transferred are given time to join up to 1st of April so as to coincide with the academic session in schools. Stop. It is submitted that as per the transfer policy, the normal tenure of a judicial officer at a particular posting is of 3 years and a period of 6 months or more is to be treated as a full year. Stop. Accordingly, the petitioner could have been transferred in March 2014 as she had already completed more than 2 years and 6 months till then. Stop. It is submitted that however the petitioner was transferred mid-term on 7th July 2014. Stop. It is submitted that the mid-term transfer as provided under clause 22 of the transfer policy can be made on the limited grounds mentioned therein. Stop. Shrimati Jaisingh submitted that none of the grounds as mentioned in clause 22 of the transfer policy were available in the case of the petitioner. Stop. Per contra, Shri Tushar Mehta, the learned Solicitor General, appearing on behalf of the respondents, submitted that the allegations made by the petitioner with regard to sexual harassment are found to be not established by the judge's inquiry committee. Stop. He submitted that the said findings were recorded as back as on 15th December 2017, which were not challenged and in any case cannot be questioned or assailed in ancillary proceedings like the present one. Stop. Shri Mehta further submitted that though the findings of the JIC with regard to transfer of the petitioner being irregular are beyond the scope of its terms of reference, at best the transfer could be construed to be irregular. Stop. He submitted that assuming that the transfer order of the petitioner was irregular and even modified, the same having not been challenged at the relevant point of time, the validity thereof cannot be challenged in the present proceedings. Stop. He submitted that the concept of coercion resulting into resignation is a concept which is developed in the Western countries with regard to labor jurisprudence, and that in any case such reliefs can be granted only when such a fact is duly established by leading evidence. Stop.